My name is Tom Olsen. The name of the show is Olsen on Law, every Saturday morning at 11 a.m. right here on News Talk WDBO. My guest today is attorney Travis Hollifield. He focuses on working women's legal rights, including sexual harassment, pregnancy discrimination, Family Medical Leave Act, and wage-related claims. He represents working women throughout Florida with workplace legal issues. Travis knows what women want. And Travis, a few minutes ago, we had a question about sexual harassment in the workplace. And so my question is, what rises to a case for a client for you that you might consider suing in court versus a client that you might come to and you say that just does not rise to the level of going to court for you?
Tom, that's always a question that the answer is it's a matter of degree. And what I mean by that is there's a fine line. It's a subjective kind of an approach that I would take as an attorney deciding whether I'm going to spend my time and efforts to commit to a case regarding what happened to the particular person in the situation at hand. In other words, if I believe that it rises to the legal standard that we mentioned earlier today, that either one instance of potential harassment was sufficiently severe or that there were several incidents that happened over time, therefore meeting that pervasive prong, we'd have to look at all of the circumstances in the particular situation and make a decision about what we thought our chances were about getting to a jury.
And if you were to file such a suit, would it be in front of a jury or would a judge be deciding your case?
Most of the time it would be a jury trial. Of course, we have an opportunity as the plaintiff to decide whether to ask for a jury trial or not. We typically do. So we would ask for a jury trial. But that's something that is usually a year or two down the road after you initiate a claim like this because of the requirement that you exhaust administrative remedies, which means you have to go through this EEOC investigative process first. Then when you're done with that, you begin litigation.
And, I don't do trial work. I don't do jury trial work. But if you're doing a jury trial, and we're talking about a lady who's been sexually harassed in a workplace, it's your job as an attorney to tell a jury what the measure of your damages, tell the jury what you think the dollar value of the damages are, I suppose, right?
That's correct.
And how do you put a dollar value? What would be a typical dollar value of a sexual harassment case?
Again, it would depend on the circumstances, but legally, we would be entitled to, we being a successful plaintiff, if we were able to establish liability against an employer, we would be able to request both economic compensatory damages, which means lost wages, if there was a termination, let's say, or if there was an adverse employment decision that caused economic damages to the plaintiff. We would make an argument for that, and that's basically an objective standard. That's something that could be reasonably mathematically found. And then there's emotional distress damages.
So what would be a range of damages that you might have received by a jury for sexual harassment in a workplace?
Well, again, jury verdicts range anywhere from zero, those are not the good days, to over six figures. It just depends on the nature of the harassment. Well, I remember a trial I had, it was about 2 years ago now, where it was, in my view, a particularly egregious sexual harassment circumstance where the employer had touched the individual female in an intimate area. And whenever there is inappropriate touching, that seems to get the attention of a jury more than verbal abuse alone.
Hey, folks, again, my guest today is Travis Hollifield. He's an attorney right in Winter Park, and he focuses on women's workplace issues, and he knows what women want in the workplace, and he's here to lend us his expertise today.